Hey everyone, Guten Tag, Guten Morgen. Today I'm going to discuss Form number 27. Now, what is Form 27 under the Indian Patent Law and the Indian Patent Act of 1970? The Indian Patent Act was enacted in the year 1970 and the Patent Rules of 2003. Now, this Form 27 talks about statement regarding the working of the patented invention on a commercial scale in India. See, we need to understand one thing. I have seen the in-house counsel speaking on this topic, but I feel there's an urgency in understanding why a patented invention, which is patented in India, why this form is a mandatory requirement under the patent law. First and foremost, we understand, or I think most of the people on LinkedIn who are intellectual in nature understand the fact that there are 8 billion people in this world, out of which India accounts for unaccounted number is somewhere between 1.35 billion. China is almost 1.4 billion, which accounts for maximum population in terms of the node. That's why blockchain technology, that's why technology which are related to the internet or to the communication network becomes very, very important in context of India and China both. Both countries have to work in synchronicity because till now, if I talk about the raw materials, whether it's the pharma sector, whether it's any of the sectors for that matter, I think China is providing that service or good. Coming back to the point of the statement regarding the working requirement of a patented invention, it's mandatory requirement on a yearly basis. If you don't do it, it becomes a clause where your patent can be revoked also. So it's my earnest request. What I'm doing is I'm providing this free service to everyone. If you have a patented invention in India and if you really want to understand what you can do with your inventions, I'm providing 15 minutes clarity call, which is free. After 15 minutes, basic charges would be charged. But what I feel is the need of the hour is to understand the innovation. The need of the hour is to understand what you can do with your patented inventions. And especially in the sector in India where renewable energy, because there are places in India where you can deploy renewable energy, and my client wind energy patent application, which has just been granted, is a apt sample to be deployed by the Indian government, by all the stakeholders, and this is an open invitation to Adani, Reliance, or any of the companies who claim to be working in the renewable sector, because I understand and I have seen, the Indian entities trying to copy the patented innovation just by reading the application, and this is not fair. When there is something called as invention, where something called as patent, the Indian counterparts, they like to copy and they just like to tweak it and make it of their own. I think that should be something, one has to ponder upon. Coming back to the sections, the applicable section of the Indian Patent Law is 146(2) and Rule 131(1). I'll just read the rule first. The rule talks about form and manner in which statement require under section 146(2) to be furnished. The statement which shall be furnished by every patentee. So patentee is the entity, individual, legal, starter, whatever, who has been granted a patent by the Indian Patent Office, and every licensee. So this is applicable to the patentee and the licensee under subsection 2 of section 146, that is Form 27, which shall be duly verified by the patentee or the licensee or his authorized agent. So here, the authorized agent like us, who are patent agents, who are qualified patent agents under the law. I qualified in the year 2006. The patent amendment happened in the year 2005. And one of the major clauses of sitting for the exam was you have to attain 21 years from the date of birth, and then you have to be a science graduate and the other requirements. And I cleared the patent agent exam at the age of 21. I was still doing my masters in biotech from Jaipur, and feel very fortunate. It has been a very enriching journey till now, and now I'm seeing those fruits, because when you draft more than 500 patent applications filed globally, whether it's under Malaysia, whether it's under any of those countries which you can even think of, like I have clients from San Marino. San Marino is world's smallest republic, and that patent application is a game changer. So currently we are looking for licensing. Though the patent is not granted, it is protected under the copyright law, and copyright law states that a lifetime of the author plus 60 years. So copyright law is the older law as compared to the patent law. The patent law was enacted in the year 1970. Copyright law comes under Bernese Convention, where the protection is under 140 plus countries. So it's an earnest request to everyone, when we say as a patent agent or as a patent attorney that you can file for copyright, listen to your agent, listen to your I would say the advice which is provided by the experts. If the experts are charging you something, they have really worked hard to become patent agent in India. I think the number of patent agents in India still I think is less than 6,000, but that's a big number. My agent number is 1241, which is dated back to 2006. Coming back to the point of Rule 131, the statement referred in Sub-Rule 1 shall be furnished in respect of every calendar year within 3 months of the end of each year. So if you say the calendar months ends in March, so you have 3 months. From March it would be April, May, June. Within 3 months it has to be furnished. So it's an urgent requirement, and please comply with it. The controller may publish the information received by him under section 1 or subsection 2 of section 146. Let's go to section 146. What is 146? Power of controller to call for information from patentees. So as I said, 3 people: the patentees, the licensees, and the authorized agent. And the authorized agent in this case is the patent agent, or it can be a lawyer also if the agent is defined in that respect. The controller at any time during the continuance of the patent by notice in writing require a patentee or a licensee, exclusive or otherwise, whether the license is exclusive or it has certain clauses that needs to be seen, to furnish him within 2 months from the date of such notice. So if a notice is issued by the controller, it has to be furnished within 2 months. Generally 2 months is 60 days. Or within further time as the controller may allow, such information and such periodical statement as to the extent to which the patented invention has been commercially worked in India as may be specified in the notice. Without prejudice to the provision of subsection 1, every patentee and every licensee shall furnish in a manner, form and such intervals not being less than 6 months as may be prescribed in the statement to the extent to which the patented invention has been worked on a commercial scale in India. Subsection 3 talks about the controller may publish the information received by him under section 1 or subsection 2 in a manner as may be prescribed. Coming back to the form, in the matter of patent number has to be mentioned. I is individual or group of individual people. V stands for a legal entity, small entity or a startup. The patentee or the licensee under the patent number hereby furnish the following statement regarding the working of the patented invention referred to above on a commercial scale in India for the year. Say for example this year would be 2021 because we have to see the earlier year. The patented invention, whether the tick boxes are worked, not worked, if not worked, reason for not working, and the steps taken for the working of the patented invention. I think the stakeholders, the government, the stakeholders should give incentives to the entities who take these licenses from the individual inventors, because see, we are trying to increase the economy of India. India is talking about 5 trillion economy, but my calculation says if we just understand intellectual property rights, abide by the law, easily it can be 30 trillion economy, and that's in India. If work, quantum and value of the patented product manufactured in India, imported from other countries, the license and the sub-license granted during the year, state where the public requirement has been met, partly, adequately, to the fullest extent, at reasonable prices. The facts and the matter stated above are true and best of the knowledge and the information and belief. You have to mention the date and signature, and then you submit it to the controller. So it's an earnest request. Working requirement of patent is very, very important. Please make sure that you file those requirements. As I said, I'm giving 15 minutes free clarity call to all the people who have patented invention in India or in the process of getting the patent in India. Thank you so much for watching out the video. Look forward to your questions. Thank you.